Vincent Harlow picked up my employment contract with both hands like he was holding something contaminated, walked over to the industrial shredder in the corner of his office, and fed it through while maintaining eye contact with me the entire time. The machine made that aggressive grinding sound, the kind that's designed to be intimidating, to make you understand that whatever just went through those blades is gone forever, irretrievable, destroyed. He smiled while he did it, that particular smile executives use when they think they're being clever, when they believe they've just solved a problem through sheer decisive action and intimidation tactics. "There," he said, watching the last strips of paper fall into the bin like confetti at the world's most depressing celebration. "No contract, no obligations. You're free to leave any time you want, and we're free to restructure your position as we see fit." He actually dusted off his hands afterward, like he'd just finished some manual labor instead of casually destroying a legally binding document while I sat there wondering if he understood how cloud storage worked. I'm Maya Chen, and I watched that performance happen on Tuesday, September 12th at 3:47 p.m. in Vincent's corner office with its view of downtown Seattle and its furniture that cost more than most people's cars and its complete absence of anything resembling legal awareness or basic intelligence. I'd been Senior Operations Manager at Cascade Systems Inc. for 9 years, 2 months, and 14 days, which I know precisely because my original employment contract, the one Vincent had just shredded with such theatrical confidence, specified exactly what happened to my compensation and stock options after 9 years of continuous service. I wasn't the loudest person in the company or the most politically connected. I drove a practical Subaru Outback with 176,000 miles on it and a bumper sticker from a national park I'd visited in 2019. I lived in a modest condo with a view of other condos and a balcony where I grew herbs that sometimes survived my travel schedule. I was the person who showed up early, stayed late, fixed problems nobody else wanted to touch, and apparently, according to Vincent's recent assessment, was now making too much money for someone in operational support. Operational support. That's what he'd started calling my role after the new investors came in with their efficiency mandates and their optimization frameworks. Never mind that I'd built half the operational infrastructure this company ran on. Never mind that I managed relationships with every major vendor and knew which systems would collapse if someone looked at them wrong. I was operational support, which in venture capital language means expendable. The trouble started 3 months ago when Cascade got acquired by Vertex Capital Partners, a private equity firm that specialized in buying profitable mid-sized tech companies and squeezing every possible dollar out of them before flipping them to larger acquirers. Vincent Harlow came with the acquisition, installed as CEO to maximize operational efficiency and prepare the company for scale. Vincent had that private equity background, expensive suits, practice charisma, and the complete certainty that people are just numbers on a spreadsheet that can be adjusted for optimal returns. His first move was reviewing all employment contracts for legacy compensation structures that don't align with current market standards. Translation: figuring out who was making too much money based on old agreements that promised things like stock options and performance bonuses and protection from arbitrary termination. My contract, signed back in 2014 when Cascade was a startup gambling on success, was apparently one of those legacy problems. It specified that after 9 years of continuous service, my base salary would increase by 15% and I'd vest an additional 30,000 stock options annually. It also included a termination clause requiring 6 months severance plus full vesting of all outstanding options if I was let go without cause. On paper, those terms were worth approximately $340,000 annually once you calculated base salary, stock options at current valuation, and performance bonuses. For someone in operational support, Vincent considered this excessive. On September 5th, he called me into his office for what he described as a compensation structure alignment conversation. He sat behind his massive desk with a leather folder containing what I recognized as my employment contract. "Maya, I want to discuss your current compensation package. We're restructuring how we approach long-term employee agreements to create more flexibility and market-appropriate terms." Market-appropriate. Code 4, we want to pay you less. Your current contract was negotiated during a different phase of the company's development. The terms reflect an outdated approach to compensation that doesn't scale as we grow. My contract reflects the value I've provided for 9 years building operations infrastructure, I said calmly. Right, but we need to modernize these agreements. We're offering everyone the opportunity to transition to new contracts that better reflect current market rates and company standards. What are the new terms? He slid a document across his desk. New contract, new terms, base salary reduced by 18%, stock options eliminated entirely, performance bonuses restructured to be discretionary based on company performance and management assessment. The termination clause changed to standard at-will employment with no severance guarantees. This is a significant reduction in total compensation, I said. It's more aligned with market standards for similar roles. And frankly, Maya, your current contract is creating budget constraints that affect our ability to invest in growth initiatives. I earned this contract through 9 years of work. It's legally binding. Vincent smiled. Not friendly. Contracts can be renegotiated when both parties agree it's appropriate. We're hoping you'll see the value in transitioning to terms that work better for everyone. And if I don't agree? Then we'd need to discuss whether there's still a good fit between your expectations and the company's direction. Translation: accept the pay cut or get fired. I left that meeting knowing exactly what Vincent was doing. He couldn't fire me without triggering the severance and stock vesting clauses that would cost the company hundreds of thousands. So he was trying to force me into signing away my contractual protections by threatening my job if I didn't voluntarily accept worse terms. That evening, I did 2 things. First, I called an employment lawyer named Rebecca Martinez who specialized in executive compensation disputes. Second, I logged into my Google Drive and verified that the scanned copy of my original signed employment contract was still there, uploaded back in 2014 when I digitized all my important documents, backed up in 3 different cloud storage services because I'm paranoid about data loss. Rebecca reviewed my contract over the phone while I waited in my condo looking at my herb garden that was somehow thriving despite my neglect. This is a solid contract, she said. Clear terms, mutual consideration, no ambiguous language. Washington is a contract protection state, meaning they can't unilaterally change terms without your agreement. If they fire you to avoid these terms, you have a strong case for breach of contract and likely wrongful termination. What if they pressure me into signing a new agreement? Don't sign anything. If they terminate you, we'll have a clear case. If they try to constructively discharge you by making conditions intolerable, that's also actionable. Keep documentation of everything. September 12th, Vincent called me back to his office. I knew something was wrong when I saw his expression, that particular mix of frustration and determination that executives get when they've decided to do something aggressive. Maya, I've been reviewing our conversation from last week. I think we need to simplify this situation. He opened his desk drawer and pulled out what I recognized as my original employment contract, the physical document from company files. Then he stood up, walked to the shredder, and performed his little theatrical destruction while maintaining that aggressive eye contact. There. No contract, no obligations. You're free to leave anytime, and we're free to restructure your position as we see fit. If you want to continue working here, you'll sign the new agreement. If not, you can tender your resignation. But the old contract is gone, so we're done negotiating terms that don't exist anymore. I sat there watching strips of paper fall into the bin, processing what he'd just done. He'd physically destroyed a legal document thinking that made it unenforceable. He'd literally shredded my contract believing that paper destruction meant legal destruction. You just destroyed a legally binding contract, I said. I destroyed a piece of paper. If you don't have the original, you can't prove what the terms were. Your word against the company's records. And our records will show the new agreement I'm offering. He actually thought this would work. He genuinely believed that destroying the physical document meant the contract no longer existed. Now, most of you listening to this are probably not subscribed yet, and honestly, that's like watching someone commit professional suicide in real time and not sticking around for the aftermath. Hit that subscribe button right now, because what happens when an executive learns about cloud storage and legal discovery is genuinely beautiful. I stood up from my chair. Vincent, I'm not signing your new agreement. I'll be consulting with my attorney about next steps. His smile got wider. Consult all you want. Without the original contract, you've got nothing but claims that can't be verified. Good luck proving terms when the only documentation has been destroyed. I left his office, went straight to my car, and called Rebecca Martinez. He did what? She said after I explained. Shredded my original contract right in front of me. Said without the physical document, I can't prove the terms existed. Does he not understand how evidence works? Or that destroying documents during an active dispute is literally illegal? Or that you probably have copies? Apparently not. This just became much easier than I expected. Send me your digital copies and every piece of communication you have with him. We're filing tomorrow. That evening, I compiled everything, scanned copy of my original signed contract showing all terms, timestamps proving it was uploaded in 2014 long before this dispute, email chains showing Vincent's pressure to sign new terms, and now his admission that he destroyed the original document. September 13th, Rebecca filed a lawsuit in King County Superior Court, breach of contract, wrongful termination, and critically, spoliation of evidence. Spoliation is the legal term for deliberately destroying documents relevant to litigation. Courts really don't like it when people destroy evidence. Judges tend to assume that destroyed evidence would have been unfavorable to whoever destroyed it. The filing included my digitally signed contract copy, metadata showing upload dates, and detailed description of Vincent's shredding performance. We also filed for an emergency temporary restraining order preventing Cascade from altering any of my employment status pending resolution. On September 14th, Cascade received service of the lawsuit. Vincent's response, according to someone still working there, was to storm around asking who'd given me copies of my contract and demanding IT do an audit of company file access logs. September 18th, we had our preliminary hearing for the temporary restraining order. Vincent showed up with Cascade's corporate counsel, an expensive lawyer named Philip Thornton who looked progressively more uncomfortable as he read through our filing. The judge, a woman named Sandra Patterson who'd been on the bench for 23 years and had zero patience for corporate nonsense, read through the complaint with increasing disapproval. Mr. Thornton, did your client actually shred the plaintiff's employment contract during an active compensation dispute? Your Honor, there was a disagreement about contract terms, and Mr. Harlow made a decision to remove outdated documentation from company files. He shredded it in front of her while telling her the contract no longer existed. That's not file management, that's evidence destruction. We dispute the characterization of, Mr. Thornton, I'm looking at a digitally signed contract copy with metadata showing it was created and stored in 2014. Your client destroyed the original thinking that would eliminate the plaintiff's ability to enforce these terms. Is that an accurate summary? Long pause. Thornton consulted with Vincent briefly. Your Honor, we believe there are legitimate questions about whether the digital copy accurately reflects. The digital copy has metadata, timestamps, and digital signatures. Your client destroyed the original during an active dispute. Unless you can provide evidence that this digital copy has been altered or fabricated, I'm inclined to accept it as authentic. Do you have such evidence? Another pause. No, Your Honor. Then here's my ruling. Temporary restraining order granted. Cascade Systems cannot alter Ms. Chen's employment status, compensation, or benefits pending resolution of this case. Additionally, I'm ordering immediate discovery of all communications between Mr. Harlow and anyone else regarding Ms. Chen's contract, her compensation, and the decision to destroy the original document. We're going to find out exactly what happened here. The discovery process was devastating for Vincent. Emails showed he'd explicitly planned to pressure me into accepting reduced terms by threatening my job. Messages to other executives described his strategy of eliminating legacy compensation problems by forcing renegotiations. Most damaging, an email to Cascade's CFO 2 days before the shredding incident, meeting with Chen tomorrow. If she won't sign the new terms, I'm going to destroy the original contract so she can't enforce the old terms if we terminate her. Premeditated evidence destruction, documented in writing, sent through company email systems. Vincent had literally created a paper trail proving his intent to destroy documents to avoid contractual obligations. October 3rd, Judge Patterson ordered sanctions against Cascade for spoliation of evidence and scheduled a trial date for November. The sanctions included presuming that any disputed facts would be decided in my favor unless Cascade could provide clear evidence otherwise. On October 10, Cascade's board held an emergency meeting. Vincent was placed on administrative leave pending investigation. Philip Thornton contacted Rebecca with a settlement proposal. October 15, settlement conference. Cascade offered full recognition of my original contract terms, 6 months paid leave while we negotiated long-term resolution, and reimbursement of all legal fees incurred. Rebecca looked at the offer and said, "That's not adequate. Your client destroyed evidence, violated contract terms, and attempted to force my client into accepting unconscionable terms through intimidation and fraud. We're seeking full enforcement of the contract, including immediate vesting of all outstanding stock options, 3 years of continued employment at current terms, and significant damages for emotional distress and reputational harm." They countered. We countered back. By October 22, final settlement, immediate vesting of all stock options I would have earned over the next 3 years, approximately 90,000 options at current valuation worth $450,000, 2 years of full salary and benefits regardless of employment status, complete release from any non-compete or non-solicitation clauses, and payment of $275,000 for damages and legal fees. Total settlement value, approximately $1.2 million. On October 25, Cascade's board announced that Vincent Harlow was transitioning to other opportunities, and would no longer serve as CEO. Translation: fired for creating $1 million legal disaster by shredding a contract like a cartoon villain who'd never heard of photocopiers. November 3, I received the settlement payment and signed the final agreement. I was effectively being paid for 2 years of work I didn't have to do, plus immediate vesting of stock options worth nearly $500,000, plus damages, plus legal fees covered. All because Vincent thought shredding paper meant destroying legal obligations. I took 3 months off to travel. Went to national parks, hiked trails I'd been postponing for years, spent time in my condo tending the herb garden that somehow kept thriving. In February, I started consulting for mid-sized tech companies on operations infrastructure, advising them on everything from vendor relationships to documentation practices to, ironically, proper contract management. 6 months after the settlement, I ran into Philip Thornton, Cascade's lawyer, at a legal conference in Portland. He approached me cautiously, like someone approaching a recently exploded landmine. "Ms. Chen, I wanted to apologize for my role in that situation. Vincent's actions put me in an impossible position. You were doing your job representing your client. I was representing an idiot who thought destroying documents was a legitimate legal strategy. I told him repeatedly that shredding your contract wouldn't eliminate your rights and would likely constitute spoliation. He insisted it didn't matter if you couldn't produce the original physical document. Did he really not understand how digital copies work? He's from a generation that thinks if you shred paper, it's gone forever. He genuinely believed you wouldn't have backups and that without the original, you couldn't prove the terms existed. When I explained that courts accept digital evidence with proper authentication, he told me I was being overly cautious. What happened to him after Cascade? Last I heard, he's working as a consultant for small private equity firms. His reputation in the Seattle tech scene is thoroughly destroyed. Word travels fast about executives who create million-dollar legal settlements through sheer incompetence. 1 year after the settlement, Cascade Systems was acquired by a larger tech conglomerate for substantially less than projected because the Vincent disaster had damaged their reputation with investors and employees. The acquisition terms included replacing the entire executive team and restructuring operations. 2 years later, I'm running my own consulting firm specializing in operations infrastructure and contract management for growing tech companies. Annual revenue exceeds $400,000 and I work from wherever I want with clients who actually value institutional knowledge and operational expertise. Last month, I received a LinkedIn message from someone at a company Vincent was consulting for, asking if I knew anything about his background. I sent a link to the public court documents from our case and said, "Make sure you keep digital copies of all important agreements." He has interesting ideas about how contracts work. The lesson I learned from this experience isn't about revenge, though watching someone learn that shredders don't erase legal obligations was deeply satisfying. The real lesson is simpler: document everything, back up everything digitally, and never underestimate how badly someone can sabotage themselves by overestimating their own cleverness. Vincent thought he was being strategic by destroying my contract. What he actually did was commit spoliation of evidence, create a documented trail of intentional fraud, and hand me leverage that converted a contract dispute into $1 million settlement. That shredded contract was supposed to erase my rights. Instead, the digital copy erased his career. Thanks for staying through this story, everyone who understands that in 2024, destroying paper doesn't destroy legal obligations or cloud storage backups. If this resonated with you, if you've ever had someone try to bully you into accepting less than you're owed, subscribe and share your story. These workplace justice tales remind us that competence and preparation beat intimidation and ignorance. Remember, back up everything important in multiple locations, understand your legal rights, don't let anyone pressure you into signing away contractual protections, and never assume that destroying physical documents means destroying legal obligations. Your rights don't disappear because someone shreds paper. In the digital age, evidence is stored in clouds, not filing cabinets, and executives who forget that learn expensive lessons. Stay documented, stay backed up, and always remember that the cloud is forever.